Usually when we sit down to look at legal documents for a deep dive, we're looking at something, well, something pretty dry.
Mm-hmm. A contract dispute, maybe?
Exactly. Or, some dense piece of legislation that puts you to sleep by about page 3.
It's the fine print of life, absolutely.
Yeah. But the document we're looking at today, I mean, this thing reads like the script of a legal thriller.
It really does.
I'm talking about a plot with, like, mysterious figures in delis, secret medical pods, and high-stakes surgery. But this isn't a movie we're reviewing. We're looking at a verified complaint filed in the Supreme Court of New York just a few days ago on February 9th, 2026.
And we should probably pause right there on that term, verified complaint. It's important context.
Yeah, let's do the glossary early on this one. What makes a complaint verified versus just, a regular lawsuit?
Okay, so in most lawsuits, a lawyer drafts the allegations. It's a story, right?
Right.
The lawyer tells it on behalf of the client. A verified complaint is different. It means the plaintiff, the person or company suing, has sworn under oath, under penalty of perjury, that these facts are true.
To the best of their knowledge, at least.
Exactly. It raises the stakes immediately. If they're lying in a verified complaint, they're in really serious legal trouble themselves.
No, they're not just throwing spaghetti at the wall. They are swearing on a stack that this is real.
Right.
Okay, so the plaintiff here is New York Marine and General Insurance Company, and they are going after a heavyweight target. They're suing Subin Associates, a very prominent New York personal injury law firm.
A very big name.
And the individual partners, Herbert and Eric Subin.
And they aren't just suing them for, like, a billing error or a disagreement on a settlement. They're accusing this law firm of running what they call the Subin blueprint.
The Subin blueprint?
Yeah. The complaint alleges it's a massive systemic enterprise designed to manufacture fraudulent injury claims, basically from scratch.
Manufacture is such a heavy word. We're not just talking about ambulance chasing here, are we? Like running after a guy who actually broke his leg and saying, hey, hire me.
No. The allegation here is much, much darker. The claim is that they are effectively inventing the injury, staging or misrepresenting the accident, and this is the part that really just stops you in your tracks. Performing unnecessary invasive surgeries on vulnerable people to create the medical evidence they need to cash out.
That is a terrifying premise. So our mission for this deep dive is to unpack this document. We need to understand how this alleged blueprint works, who the players are, and why an insurance company is invoking a law that's essentially the death penalty for lawyers.
It's a complex machine. You really have to take it piece by piece.
Okay, so let's start where the complaint starts, with the human element. The patient zero for this specific lawsuit, a man named Napoleon Aquino.
Right. To understand the macro scheme, you have to look at the micro timeline of Mr. Aquino. According to the filing, Aquino claims he was involved in an accident on June 12, 2019.
Okay, June 12th. Does he go to the ER? Does he call 911?
No, he goes home. But the very next day, June 13th, the machinery, it just starts turning.
Yeah.
First, he signs a retainer with the Subin law firm.
Right.
And then he goes to a reputable major hospital in New York Presbyterian.
That all sounds pretty standard so far. You get hurt, you get a lawyer, you go get checked out.
Sure, but look at the medical records that are detailed in the complaint. At the hospital, Aquino rates his pain as a 2 out of 10.
A 2.
A 2 out of 10. The doctors do a full workup. They find no trauma, no objective signs of a neck injury. They essentially say, you're fine, go home.
A 2 out of 10 is a stubbed toe. It's a nuisance, not a catastrophe.
Exactly. But then, fast forward just 24 hours. June 14th, Aquino walks into a clinic called Allborough.
Allborough.
And suddenly, the whole narrative just flips completely.
Yeah.
His pain is now a 9 out of 10. He's allegedly totally disabled.
Whoa, hold on. How do you go from I'm fine at a major research hospital to I'm in agony at a neighborhood clinic in one day? Did he fall down a flight of stairs in between or something?
The complaint says no. There was no new incident. The only thing that changed was the venue. The insurance company alleges that Allborough is the entry point for the blueprint. It's where the medical record gets, rewritten to match a lawsuit rather than the patient's reality.
But here's the part that I really struggled with when I was reading the source material. It just feels like a glitch in the timeline. A week later, he goes back to the hospital.
Yes. On June 24th, he goes back to New York Presbyterian to get medical clearance for a new job.
A new job. Okay.
And guess what he tells them?
Let me guess. 0 out of 10.
0 out of 10. The doctors write, and this is a quote, no physical or psychological barriers to employment.
So we have a sandwich. Hospital says healthy. The clinic in the middle says disabled, and then the hospital again says healthy.
A rational observer would say this man is fine. But the blueprint, allegedly, ignores the hospital sandwich. They just take that all-boro filling and they run with it.
Wow.
They send him down a very specific pipeline of doctors. Dr. Kolb for radiology to find an injury, and then a Dr. Michael Gerling for surgery.
And we're not talking about, like, physical therapy or some ibuprofen.
No. On February 6, 2020, Napoleon Aquino had a cervical fusion. Let's be really clear about what that is.
Please.
They cut into his throat, they move his airway aside, remove a disc from his spine, and screw a titanium plate into his vertebrae to fuse them together permanently.
I just want to pause on the why. Why surgery? If the guy is telling the hospital his pain is 0, why on earth would he agree to someone slicing his neck open?
This is the most disturbing part of the whole complaint. It alleges that Aquino was severely mentally ill. He had been involuntarily committed to a psychiatric ward just 3 weeks before this surgery.
Involuntarily committed, so he was deemed, what, a danger to himself or others?
Correct. And he was committed twice more during the pendency of his case.
Oh my.
The insurance company argues he was in absolutely no position to give informed consent. They claim he was a pawn. The surgery creates what lawyers call damages.
Okay, let's unpack that term for the listeners. Damages. Why does the surgery matter so much to the lawyer?
In personal injury law, the value of a case, the price tag, is largely based on the severity and a permanence of the injury. A soft tissue injury, like a sprain, a bruise, whiplash, that might be worth $5,000 or $10,000.
Right, because it heals. You get better.
Exactly. But a spinal fusion, that is permanent. You have lost range of motion forever. You have hardware in your body. That pushes the potential verdict into the millions.
So the surgery effectively turns a $10,000 case into a $2.8 million case.
That was the demand in the Aquino case.
Okay.
Over $2.8 million. The allegation is that the surgeries wasn't for the patient's health, it was an investment in the lawsuit.
That is chilling, to think of medical care being driven by a calculator instead of a diagnosis. But the complaint argues Aquino isn't just one unlucky guy. He's a product on an assembly line.
Right. The insurance company calls it the Subin blueprint, and they break it down into 4 distinct steps. It's almost industrial in how it's described.
Okay, walk us through the steps. How does this machine supposedly work?
Step 1 is the recruit. The complaint alleges the firm targets vulnerable populations. We're talking about recent immigrants who might not speak English well, people with substance abuse issues, people on parole, or, folks like Aquino with severe mental health struggles.
People who might be desperate for cash or, frankly, just easily manipulated by an authority figure in a suit telling them what to do.
Exactly. People who won't ask too many questions about why they need an MRI for a minor bump. Then you have step 2, the runner.
Runner? That sounds like something out of a drug operation.
The concept is pretty similar. These are street-level recruiters. They aren't lawyers. The complaint names guys like Arnulfo Serrano or these mysterious figures like Mr. O. They hang out in delis on street corners. They identify the recruit, maybe someone who looks down on their luck, and steer them specifically to the Subin firm.
There was that story in the source text about the deli, a guy named Pierre Santos.
Yes, Santos. It's a perfect example of this runner dynamic. Santos had just gotten out of federal prison, was in drug treatment. He says he's standing in a deli, and this Mr. O walks up, hands him a Subin business card.
Wow.
Santos testified he had no plan to sue anyone until that card hit his hand.
So the runner hands off to the firm. What's step 3?
Step 3 is the circuit. This is the closed loop of medical providers. The complaint alleges you don't just go to any doctor. You can't go to your family GP. You go to Alboro. Then you go to Dr. Kolb for imaging. Then you go to Dr. Gerling or Dr. Wirt for surgery.
So it's a closed ecosystem.
It has to be. Because an independent doctor might say, you don't need surgery, you just need some yoga. The circuit doctors, allegedly, are there to say yes.
Okay, and step 4 is the funding. And this is the part that always confuses me. How do these folks pay for a $100,000 surgery if they don't have money?
They don't pay. And they don't use health insurance. It's all done on lead.
Okay, break that down for me. Explain it like I'm 5.
Okay, so imagine you want to buy a high-end TV. You can pay $500 cash now. Or you can use a predatory credit plan that charges you $2,000 for the same TV, but you don't have to pay a dime until next year. The doctors allegedly charge these massive inflated rates way above what Blue Cross or Aetna would ever pay. But they agree to wait for payment until the lawsuit settles.
But why would they want to inflate the cost? Doesn't that look bad?
It looks great to a jury. Economic damages are a math equation. If I show a jury a medical bill for $150,000, the jury thinks, wow, he must be really hurt.
Right.
If the bill is only $5,000, it looks minor. The inflated lenian pumps up the value of the entire case. It anchors the settlement negotiations at a much, much higher number.
So the doctor gets a huge payday later, the lawyer gets a bigger third of the settlement, and the client...
The client gets a titanium plate in their neck and whatever is left over after everyone else takes their cut.
This all sounds like a massive conspiracy theory. I mean, if you just looked at Equino, you could maybe say, okay, maybe that's one bad case. Maybe the doctors just disagreed.
Mm-hmm.
But the insurance company did something really smart here. They looked for the glitches in the matrix.
This is the web of coincidence section of the complaint. And honestly, this is where the data just becomes damning. They found patterns that, they just defy statistical probability.
Okay, let's talk about the witness. This one blew my mind.
Lisa Acosta. So every accident usually needs a witness to prove it happened, right?
Yeah.
Lisa Acosta was the witness for Napoleon Equino's fall. She vouched for him.
Seems helpful. A good witness.
Except Lisa Acosta was also a client of the Subin firm. She claimed she fell a year prior. She went to the exact same doctors, all Borough, Kolb, Gerling.
Okay, so birds of a feather flocked together. Maybe they're friends who recommended the same lawyer.
Sure, maybe. But explain this. Lisa Acosta had the exact same surgery, an anterior cervical discectomy and fusion, performed by the same doctor, Dr. Gerling, on the very same day as Napoleon Equino.
Wait. The plaintiff and his witness were in the operating room back to back.
February 6, 2020. Dr. Gerling operates on the guy suing, and then immediately operates on the witness who vouched for him. Both Subin clients. Both referred to the same pipeline. Both getting fusions.
What are the odds? Two friends, two falls, same lawyer, same surgeon, same day.
Statistically, depending on the prevalence of spinal fusions in the general population, it's virtually zero.
Okay.
It just suggests coordination.
It has to.
But the complaint says this isn't a fluke. It's a feature. They highlight what they call the Ortiz pod.
The Ortiz pod. It sounds like a sci-fi collective or something.
It's a group of 12 different claimants. The complaint links them all because they either listed the same Manhattan apartment as their address or were connected to that runner we mentioned, Arnulfo Serrano.
12 people living in one apartment.
Unless it's a frat house or a very, very crowded hostel, it's pretty unlikely. But 12 people from this one specific pod all claimed injuries. All hired Subin. All Borough. All went to Kolb. And many ended up with surgeries.
It's like a franchise. You have the pod franchise of plaintiffs.
And then you have the impossible plaintiff, Derail Wright.
Oh, this story. Tell us about Derail.
So Derail Wright claimed he tripped on a step in his girlfriend's apartment building. He sues the building owner. He enters the blueprint loop. He gets the spinal fusion from Dr. Gerling.
Okay.
He's got the surgery. He's got the hardware. He's ready for court.
But the defense lawyers, the insurance company lawyers, they do their job. They subpoena the girlfriend. They put her under it. She says, I don't know who Derail Wright is. He is not my boyfriend. He's never lived here.
She had never met the man who allegedly tripped in her house.
Never. The lease records showed no trace of him. So you have a man who underwent major spinal surgery based on an accident at a stranger's house that likely never even happened. That is the part I just can't wrap my head around. I get lying for money. People do that. But getting your spine fused for a lie, that is a level of commitment or desperation that is just hard to fathom.
And that's where the medical legal engine comes in. If a doctor in a white coat tells you, you are injured, you need this to fix it, and your lawyer says you need this to win your case, and you are someone with limited education or mental health issues, do you have the agency to say no?
You trust the professionals.
Exactly. You assume they have your best interest at heart.
So New York Marine and General Insurance has clearly had enough of this. They aren't just trying to get the Equino case dismissed. They have gone nuclear. They filed a plenary action.
Right. So normally, if an insurance company thinks a claim is fake, they fight it within that specific case. They file a motion to dismiss or they argue it in front of a judge. But here, they stepped outside the injury case entirely. They filed a completely separate lawsuit against the lawyers directly.
And they're using a very specific weapon, Judiciary Law Section 487.
This is the scary one for attorneys. Section 487 is an old New York law from like the 1800s. It targets attorney deceit. It says if an attorney is guilty of deceit or collusion with the intent to deceive the court, they are liable for treble damages.
Treble meaning cripple.
Triple the money. But the money is almost secondary. A finding of liability under Section 487 is career suicide. It's a stamp of fraud on your law license. It essentially says you are not an officer of the court, you're a con artist. It's very, very rarely used successfully because the bar is so high.
But proving fraud is hard, isn't it? You have to prove they knew. Can't the lawyers just say, hey, we believed our client, we believed the doctors, we aren't doctors, we're just filing the paperwork?
That is the scienter argument proving intent. And the Subin firm will almost certainly argue exactly that. We zealously represented our clients based on the medical reports provided to us.
So how does the insurance company plan to overcome that defense?
They argue that the pattern is simply too big to ignore. They're saying you didn't just have one client with a sketchy story. You had 28 claimants in these specific pods. You had the witness and the plaintiff getting surgery on the same day. You had the hospital records contradicting your clinic records every single time.
So they're saying you aren't the victims of lying clients, you are the architects of the lies.
Exactly. They argue that the blueprint requires the lawyers to manage the traffic. You can't run a scheme this complex with this many recurring characters without the law firm being the central nervous system. They claim the lawyers are managing the pods.
So, big picture time. Why should the listener care? I mean, insurance companies are giant corporations. If they lose a few million, does it really affect me?
It absolutely affects you. The complaint explicitly links this to the cost of living crisis.
Okay, connect the dots for us. How does a fake surgery in Queens affect my rent?
Well, when insurers pay out millions for fake claims, that money has to come from somewhere. So they raise premiums. If you own a car, your insurance goes up to cover the losses from fraud. If you rent an apartment, your landlord's liability insurance goes up, so your rent goes up. If you hire a contractor, their insurance costs are baked into the bill. The complaint cites a New York Post investigation claiming these losses have tripled since the pandemic.
So the Mr. O and the deli recruiting people isn't just ripping off some nameless corporation. He's effectively reaching into my pocket.
Correct. We all subsidize fraud. And there's a moral cost, too. The complaint references reporting from ABC News regarding migrant exploitation. These schemes often use people who are new to the country, who are scared, as raw material.
Yeah.
They get used, surgically altered, and tossed aside with a fraction of the payout.
It corrupts the entire system. The courts are supposed to be for justice. If a jury hears about the blueprint, are they going to believe the next guy who's actually truly hurt?
That's the danger. It breeds cynicism. Real victims get viewed with suspicion because fraud rings have poisoned the well. If you have legitimate spinal injury, you might face a jury that thinks, is this just another blueprint case?
So where does this all stand right now?
It's brand new. It was filed February 9th, 2026. The Subin defendants haven't even filed their answer yet. And we have to reiterate, in the eyes of the law, these are just allegations.
Of course.
They are innocent until proven liable. They will have their day in court to explain why Lisa Acosta and Napoleon Aquino had surgery on the same day.
But the insurance company has put 28 specific cases, names, dates, surgery logs. They've put it all into the public record.
It's a put-up or shut-up moment. They are not hiding their cards. They threw the whole deck right on the table. They're inviting the court to look at the raw data.
It's going to be a fascinating battle to watch. It really feels like a turning point.
It could change how personal injury law is practiced in New York. If this lawsuit succeeds, it sends a massive warning shot to other firms that might be operating similar mills.
Here's the thought I want to leave you with today. We see the billboards all the time. Injured. Call now. We assume there's a filter. We assume a doctor won't operate unless it's necessary. We assume a lawyer won't file unless it's true.
We assume the guardrails of professional ethics are working.
But if this blueprint is real, those guardrails aren't just broken. They've been dismantled and sold for scrap. If a system can allegedly take a mentally ill man and put a titanium plate in his neck for profit, how many other accidents are we paying for every day without even knowing it?
That is the billion-dollar question, and frankly, the answer might be uncomfortable for everyone involved.
Thanks for diving deep with us. We'll keep an eye on this docket and update you as the Subin firm responds.
Stay skeptical out there.
And watch your step.